This is all theater. This is all just political theater.
Political theater. Political theater.
Pure political
theater.
Theater.
Political theater.
The
nefarious,
significant and protracted
political theater for political theater's sake.
I yield back.
From Washington, this is Political Theater, Roll Call's review of the spectacle of politics on Capitol Hill and across the country. I'm Jason Dick. The Supreme Court starts its new term this coming Monday, October 7th. And while the docket does not include such high-profile cases as the last couple of years, when the justices overturned Roe v. Wade and granted presidents wide immunity over official acts, the High Court will still consider matters of constitutional rights that could reverberate for years. And they also might be called upon to referee any lingering fights over the current election season. What better way to unpack all this is to talk to our Supreme Court staff writer, Michael McAnoney, and his editor, Todd Ruger. Mike, Todd, welcome back to Political Theater.
Thanks for having us.
Yeah, thanks. Great to be here.
I think it's for a while, I feel like we had a lot of court stuff, and maybe it was just like the court cases that we were talking about. You know, it's been a little while. I mean, the court really did sort of scurry out of town after its term over the summer. But, you know, Mike, you've got a preview of the term that we're going to be running in roll call in the next day, and it'll be in roll call print as well. But this is a good way to sort of unpack it, your reporting. And one of the things that stuck out to me reading it was that a lot of this is like Supreme Court preview season, in Washington. A lot of people are saying like, oh, this is going to be sleepy. It's going to be dreamy. It's going to be boring. And yet we still have some pretty consequential stuff on the docket. Let's talk about some of those cases, including the one that, you know, they'll probably be arguing sometime in the next few weeks in October, which has to do with the Biden administration's rule about ghost guns. Let's talk about that case first.
Yeah. Starting off with the ghost gun case, the first of a bunch of cases this term, which are sort of continuing the long-term sort of hostility of this current Supreme Court to the current status quo of the executive branch power. This one in particular is a challenge to the Biden administration's framer-receiver rule, basically kits that you can buy, and it's like one mechanical step away from being a functional gun, that you can take a drill press or some other tool, make one change, and it's a functional framer receiver. Biden administration said, no, those should be serialized. They should have serial numbers. They should only be sold with background checks. And there's a bunch of challengers who have said, well, no, these should be regarded as hobby things. They're not actually that big of a problem. And also the federal law that you're using doesn't give you the authority to do that. Now, an interesting twist here is this is echoes of a similar argument that was made in a case last term, which actually ended up with the Supreme Court throwing out a Trump-era rule that banned or restricted bump stocks, which are rifle stocks that are attachable to just any rifle that allow it to mimic automatic fire. Supreme Court said, no, you can't regulate that like a machine gun. A machine gun's definition is very focused on the trigger mechanism. So a big question here is, how much is the Supreme Court going to focus on the mechanics of a frame or receiver of a firearm versus what Congress, said they intended to do with the statute, which is prevent people from making untraceable firearms.
Right. And so this will probably be the biggest case that we see, in October, before we get into, the election is going to kind of take over. It's not that the court doesn't take a break, but like this will be like the biggest case that they'll appear before the election, though.
Yeah, most likely, unless, some sort of emergency comes up in some state around election procedures ahead of election day. This is pretty much the biggest case that we're going to see before the November election.
And Todd, like you're you're now in the editor's chair for the Supreme Court, but for years you also covered the court. the justices seem to get off. I hesitate to say slow start because they're always working, right? I mean, there's always a work, but like this seems to be sort of the pattern. They don't like to throw the biggest case necessarily right in October. They want to sort of space them out over the year.
Yeah, that's true. I mean, just going back to that case, though, I think the timing of it is kind of interesting because it is true that last term they looked at the bump stock rule and they said this isn't in the law, it's not in the text, and it's hard to see them not doing that again for this regulation, where they just sort of kick it to Congress and they say if you don't want to see ghost guns on the street, then you guys need to more directly write a law about that. And But this is a major theme of the campaign. You've got the Biden administration pushing gun regulations. Even last week in a big speech, it was an announcement about their big task force for reducing violent crime. And ghost guns has been a thing they've been pressing Congress to do. And so maybe the justices could be convinced enough by the danger of having these ghost guns out there to say like this is fine. But I wouldn't bet on it. But yeah, it is one of the more salient election issues ahead of this, but mostly the Supreme Court is all about managing their docket, and they are, over the years, it's to me been very clear that they are very conscious of what cases they're taking, what order they're putting them in, and leaving room for cases that they consider to be coming down the line. And we do have kind of a slow start now, but they have met and will be announcing on Monday more cases that they could take. So we could get a couple of big issues added to this term starting Monday. But as of right now, the last term that ended in June was had so many big blockbusters in it, just so many huge issues that related to American life, that even back last term, people were saying it looks like they want to just kind of step back a little bit from all these changes. And then another argument you could say is they made all these big changes to kind of put themselves on a glide path to do smaller incremental things. And so now we're seeing those. And there's maybe a little bit of a lull before what they did last term makes its way back up to the court.
Yes, because they have the emergency room care, the EMFLA law. I mean, that was just remanded to the district court, so there's a possibility this could, find its way back, sometime in the next few months. So.
Right.
And talking about that pattern, there was a big gun case a couple of years ago, Bruin, that really shook up what gun rights are in the country. But it took 2 years for another case around gun rights to make it back up to the court, which they just did this past term. So it takes a little bit of time. The legal world works at its own pace. So we might see the reverberations of these big cases from last term out years and years from now.
Let's talk a little bit more about some of the other really significant cases that we know, that at least we know at this point, before we talk about the potential dark cloud hanging over it all, which is election cases to come. But let's talk about constitutional rights. There seem to be two. I hesitate to call them related, but they do concern minors, and how states are approaching what the states are arguing is protecting kids, but also may be going a step too far in regulating. So let's talk about the Tennessee case, which is about gender affirming care, and then we'll talk about everybody's favorite topic, pornography in Texas. But let's start with gender affirming care for minors in Tennessee. That particular case and what the contours of it are.
Yeah. So this is specifically a Biden administration challenge to a Tennessee law that restricted care for trans kids, transgender children who are seeking care, and specifically restricted them from receiving that care in order to transition. Biden administration and also a bunch of parents and families challenged this law, arguing that it discriminates on the basis of sex, a constitutional claim, arguing that, for instance, a child can receive hormones, puberty blockers for any number of medical conditions, but not to transition. The state has argued that they are allowed to, regulate medical care in furtherance of, protecting children. There's some statements in the law about, ensuring dignity of their sex and appreciation for their sex, things like that. And at the core of this case is kind of a fight about whether to consider this medical regulation or, possibly discrimination. And on that point, there was a 2020 case at the Supreme Court around LGBT discrimination in employment law. And that was just in federal law, just in federal employment law. Big question for the court this term is whether they are going to apply that finding for federal employment law to 14th Amendment constitutional claims, which makes it much, much broader. The court has also changed considerably since that decision came down. Justice Ginsburg died. We have now Justice Barrett, who is now on the court, and that was a 5-4 decision in 2020. So a lot of questions around this case.
And then the Texas case. Let's talk about pornography.
Yes, talking about pornography. So this is a Texas law requiring specifically pornography websites to verify the ages of their users with a government ID. So if you are over the age of 18 in Texas and want to access a porn website, you would have to send a photo of your government ID to access that porn website. And there's a coalition of people who are saying, like, hey, that infringes on our rights to be able to get access to this porn, which is still protected speech. It is still something that the government cannot ban. And this is the government putting an extra restriction on it, basically is the argument. Whereas Texas is arguing that, we've got an interest in protecting minors from this content. And the hurdle of proving that you are who you say you are, that you are over the age of 18, is not significant enough that it overrides our interest in protecting minors from getting access to porn. There's all sorts of technical arguments around, how easy it is to evade the law or how much of a risk it is to put your ID online, things like that. But that's really the core of what's going on there. And it's about as unsexy as a case about pornography can be.
And when we were sort of discussing some of the cases just off mic, Todd, you were noting that like some other states have tried this, and then saw a huge uptick in VPN use.
That's right. Yeah. No, I mean, and that's I think sort of the part of this case that's interesting is what the justices will think the burden of showing your identification online is compared to in person. Because if you just have to hold up your driver's license to a clerk to prove that you're 21 to buy beer, then it's not on file and it can't be, hacked later and your information released. I mean, I think we've just seen.
Or just sold is another concern that people have brought up.
Yeah. Data broking.
Yeah. And we saw the
data brokering.
I think Ashley Madison leak, rear its head again recently. It's like still out there. So, that data just doesn't go away and your connection to a website doesn't go away. And so people are saying it's actually a larger burden, to have online verification than in person. So, I tend to think that, the Texas victory could happen here where they could have this law succeed, but it doesn't. The history of the cases that the Supreme Court has had kind of leans the other way.
All right. I feel like those are the most high profile cases that we know of at this point. Again, we'll get ghost guns, the arguments on that before the election sometime in the next couple of weeks. We'll get these other two cases a little bit further down the line, and maybe we'll even find out, in the next couple of weeks about the schedule there. And as you pointed out, Todd, they may, mention, they may, put a few more things on the docket. But the thing that has to be hanging over John Roberts' head, at least, as he manages the caseload, is knowing that in 2020 and going into 2021, we saw a lot of litigation about the 2020 election season, particularly from Donald Trump, but not relegated to him. There were lot of cases that found it their way. A lot of cases died at the district and magistrates level and different boards and so forth. But there is a possibility, that Trump, particularly if he doesn't like the results, may sue. And he might not be the only one who sues, depending on what the results are. Mike, how much of this is like are the people that you work with, are they just bracing for this onslaught of litigation that could result from the election?
Yeah, a lot of the people who I've talked to have sort of hedged their bets, like, yeah, the court doesn't really like to get involved in these sorts of things, but we don't know. And another thing that is two big things that are relevant here. First is the decision from the Supreme Court a couple of years ago in Moore v. Harbor saying that state legislatures' election rules for federal elections are subject to review by state courts. And we, the federal courts, are only going to get involved if it's egregiously wrong, like the state court was making something up in order to rule the way it did. And then there's also a statute that's been passed by Congress since the 2020 election, which is the Electoral Count Reform Act, which, in addition to the thing a lot of people paid attention to, which is, making sure to specify all of the things for the actual electoral count in January, it also laid out procedures for court challenges to election results in the wake of the election. So that statute hasn't been tested yet in court. There could be some stress testing in the next couple of months, but at the very least, there is a procedure that's laid out in a federal law for how this is supposed to happen. If that's actually how it happens, we don't know yet. But there's at least a law that lays it out now.
And we should note, too, that the former president, Donald Trump, has already, asked the Supreme Court to put a halt to the release of evidentiary findings in his case here in D.C. related to his attempts, his trial over January 6th and what his role was in the violence and the attempt to disrupt the electoral count. So we may, the court could just bat it aside like they have a lot of these in the last few months, or they could open themselves up to even further attention by saying we're not going to allow the evidence to be released. We're going to overturn the district court judge's decision to release that information. So we may get a little primer, if you will, on this. And I'm glad to hear you say that it's supposed to be run a little smoother than in the sort of chaotic situation we had 4 years ago. But it seems like we would be wise to be prepared for just about anything. Yes. Yeah. It's nobody knows what's going to happen right now, but everybody's like, let's be ready for things to be unsettled, basically, is what the vibe that I've gotten from people. Yeah. And not to get too far away from just, looking at previewing the court's term and so forth, but I wanted to also leave by asking the both of you. I mean, there's been a lot of news stories about Clarence Thomas, Sam Alito, their two justices who have accepted free trips and, have run afoul under any other judicial level in the federal government, and the judicial branch would have been afoul of ethics laws, but because the Supreme Court makes its own ethics rules and enforces its own, they're not, they didn't get into trouble. Are we going to see anything from Congress, anytime soon, or is this just going to be one of those topics that comes up over and over again until somebody just, it just dies? The ethics laws. Mike, let's go with you, and Todd, we can finish, with your.
There is almost no appetite whatsoever for anything bipartisan to do with judicial ethics at this, or I should say, justices' ethics at this point. And it covering judiciary issues for a while. There are issues that will hang around this kind of stuff for literal decades. before anything gets done. Partially because there are so few justices that anything involving the Supreme Court immediately turns both personal and political, which are two things that make it very difficult to get anything bipartisan done.
Todd, I mean, you've been hearing some of the same things about, ethical issues for years. I mean, is it just something that, like, in particular, Democrats will continue to use as a political issue because they're the justices they're targeting are the ones they don't like the most?
Yeah, I mean, my view on this has always been, that there is the partisan problem that Mike talked about, but there's also these huge structural issues that make me pessimistic that anything would ever happen. Number one, even if Congress got together and passed a law, the Supreme Court could hear a challenge that says it's unconstitutional and rule it unconstitutional. But then there's also these structural things just in Congress itself. The one that I always use is, for reforming the Supreme Court more generally. A lot of people say, like, maybe there should be term limits of 18 years for the justices. But there's just no way I can conceive of that the Senate would readily give up its power to do the confirmation process on Supreme Court justices. And if they don't get it done in time, well, I guess then the person just gets on the court or something. I mean, it's just any of those structural changes would be the Senate giving up its own power to oversee the court and the justices. And it's just not going to happen. So as pessimistic as Mike was, I'm probably even more pessimistic. I just think there are
it's a pessimistathon.
Yeah, and I win. So yeah.
No, I mean, I think, one of the reasons that I like to keep talking to you guys, about these topics on the podcast and otherwise, and making sure that we have this a part of Roll Call's editorial mission is that, the court has always sort of skated by a little bit with a lot of lack of attention to it. And meanwhile, it is easily the most consequential. It's making the most consequential decisions in government, particularly over the last few years. And it's happening increasingly in a way that the court itself is more insulated, and less. It seems less concerned with either the public or the other branches of government. They're just. I mean, it really is this sort of like, yeah. Oh, that's a nice little rule you have. Oh, that's a law. Like you noted, there's nothing preventing us, even if Congress did pass a law for us getting Marbury versus Madison Part 2. So
and the less the Congress accomplishes because of partisan gridlock, the more policy issues get challenged in the court when the president tries to do something about it. And we've seen that for the past 3 presidents with immigration issues, for example. I mean, Congress hasn't done anything for decades on that. And so presidents try to do their own thing and just ends up in court, and you have judges making immigration policy.
And also talking about administrative law, I know I'm not going to dive into the weeds on this, but Congress hasn't passed environmental legislation in a long time. But in every single term in the last 5 years, the court has effectively made policy around environmental law with their decisions.
Yeah. As somebody with an environmental sort of journalism background, I mean, it is, arguably the most significant legislation of the last half century were the Clean Air Act, revisions in the early 90s, which is a while ago. All right, well, let's end on that very positive note about gridlock and the superpowers of the Supreme Court. This is going to be. I'm glad we're tuning in early because this is. I think that every Supreme Court term has the potential to be sort of a big one. So thank you very much for your coverage on it, and thanks for coming and talking about it on the podcast.
Thanks for having me.